The next case I'd like to talk about is Inrated Conservatorship of Daniel Allen. And here, I mentioned this earlier in my remarks, but this is a case out of Judge Kennedy's court in Davidson County. And it was a situation where first the Department of Human Services filed a petition. Shortly thereafter, the facility where the respondent was residing or being cared for filed a second petition. The court ultimately appointed guardian ad litem. The guardian ad litem determined in talking with Mr. Allen that he was going to contest the conservatorship, although he probably needed it, but he was going to contest it. And therefore, Judge Kennedy appointed Mr. Sandoval as Mr. Allen's attorney ad litem. And so through natural progression of the case, it came down to the issue of who would be responsible, the state or the facility or Mr. Allen for the attorney ad litem's fees. And the court, Judge Kennedy, ruled that pursuant to Tennessee Code Annotated 34-1-125B, that it didn't have discretion to waive the provisions in that statute. Therefore, the attorney ad litem fees had to be charged to the respondent, Mr. Allen. That issue went up to the Court of Appeals. Mr. Sandoval and LP North determined that they wanted to appeal. And two issues were brought up: whether the court had discretion to waive, pursuant to 34-1-121A, the requirement under 34-1-125B that the respondent pay the attorney ad litem fees. Also, Mr. Sandoval raised the issue of whether attorney ad litem fees were recoverable under Tennessee Code Annotated 2012-119A. And so the Court of Appeals went through attorney's fees. We followed the American rule in Tennessee and so forth, where each pays their own. And the court cited the statute 34-1-125B that simply says the cost of the attorney ad litem fees shall be charged against the assets of the respondent. Not if or may, possibly, shall be. And the court went through statutory construction, legislative intent, and said that Section 125B unambiguously states that the cost of the attorney ad litem are to be assessed against the respondent. Section 121A unambiguously gives the trial court authority to waive requirements when waiver is in the respondent's best interest. Nonetheless, after applying the rules of statutory construction, we have determined that Section 121A does not give trial courts the discretion to waive the 125B mandate. So attorney ad litem fees are to be charged against the respondent. The court went on to address the argument regarding the Title 20-12-119 and said that also did not give the trial court the authority to waive anything or to charge the provisions. It would be improper to charge the state for those fees. And then the facility here, the court determined that the statute just says the respondent has to pay for attorney ad litem fees. But a good case, another one that's not very long. It's a good read. I would recommend it as well. The next case, Inrated, the Conservatorship of Muldoon. This came out of the probate court for Cumberland County, Judge Larry Michael Warner. And this was assigned on briefs and filed June of 2020, so June of last year. And this is a situation. Mr. Muldoon had a stroke in 2015, and he and his wife had been married at the time the petition was filed for 37 years, I believe. It was filed in 2017. Mr. Muldoon's stroke left him completely paralyzed on his left side of his body, and he was absolutely dependent on someone else for basically everything that he did. And in 2017, his wife decided to seek a conservatorship with the probate court in Cumberland County. And this is the classic situation where Mr. Muldoon had enough capacity to not want anybody to take away his authority, his autonomy, but also not having the ability to be autonomous.
We as judges see this all the time. And you as attorneys see it all the time as well, and conservators. But this is just, it's a sad situation. Mr. Muldoon was not able to care for himself. He was absolutely dependent. And the court went on to reason that his wife of 37 years she was really looking out for his best interest. And she had done an incredible job taking care of him for the 2 years preceding the filing of the petition. And I misspoke. He had the stroke apparently in 2016, and the petition was filed in 2018. I was a year off on both. But the doctor's statements stated that he suffered cognitive impairment and vascular dementia. So he was just simply unable to function on his own. And the court, while respectful of Mr. Muldoon's position, simply determined that he absolutely had to have somebody take care of it. The Court of Appeals said because of the importance of autonomy, it's well settled that the law presumes that adult persons are sane rather than insane and capable rather than incapable to direct their personal affairs until satisfactory evidence to the contrary is presented. So there's a presumption, and we all know this, that everybody is capable of taking care of themselves. In order for a court to appoint a conservator over the individual's person or property, the petitioner must prove two elements: that the individual for whom the conservatorship is sought is fully or partially disabled, and two, that the individual for whom the conservatorship is sought is in need of assistance from the court. Clear and convincing evidence eliminates all serious or substantial doubt concerning the correctness of the conclusions to be drawn from the evidence. Evidence satisfying this standard will produce in the fact finder's mind a firm belief or conviction regarding the truth of the factual proposition sought to be established by the evidence. Many of these cases quote Inrated Groves. If you've done this very long, you're familiar with that case. I think that's a 2003, Court of Appeals case. But Inrated Groves has a fantastic discussion about the process, what is required, the statutory elements, basically everything regarding conservatorship, and many cases rely on 2003. The Court of Appeals in Muldoon determined, upon analyzing the record before us, we must agree with the trial court that the proof shows that the respondent is in need of a conservator. Petitioner and Ms. Jewell each testified at length. Ms. Jewell was his nurse practitioner. She was aided in his care for many years. And the petitioner, of course, was Mr. Muldoon's wife. But they both testified at length of the respondent's inability to complete essential tasks, including walking, using the restroom, eating, dressing, and bathing. Based on their testimony, it is clear that respondent needs care from the moment he wakes up until the moment he goes to bed. While respondent testified that he could complete certain minor tasks on his own, including showering while sitting, brushing his teeth, and making telephone calls, the trial court appears to have placed greater weight on the testimony of petitioner and Ms. Jewell. So this is, again, the classic situation. This man was, I'm sure, proud and like anybody, didn't want to give up his autonomy, but the court determined absolutely had to appoint his wife as conservator. The Court of Appeals ruled there is no evidence in the record that preponderates against the trial court's finding that respondent is a person with a disability within the meaning of 34-1-101-14. And that brings me to Inrated Conservatorship of Trapp. This was the most recent conservatorship case on appeal that I could find. Now, I'm not saying I did an exhaustive search, but I did look in LexisNexis. And it is somewhat interesting. This comes out of the Chancery Court for Fayette County, Chancellor Cole there, and this was published here, Court of Appeals, I believe, January 22nd of 2021. And the question is whether a trial court had the authority under Tennessee Code Annotated 34-3-107 A2P
and 34.3108F to award attorney's fees to counsel for the co-conservators of a ward when the court dismissed a petition to remove one of the conservators. So the Court of Appeals determined, and the trial court did award over $30,000 in attorney's fees to the co-conservators. The Court of Appeals determined that the trial court abused its discretion in awarding the attorney's fees to the co-conservators because the co-conservators were not prevailing parties pursuant to 34.3108F, because the petition was not to seek to enforce rights, but rather to remove one of the co-conservators. So it's interesting. What you had here was, I think 6 or 7 siblings had asked that the court remove one of their siblings as the conservator for the ward. And so in November of 2015, a petition to appoint co-conservators of the person of Miss Mary Ann Tapp was filed in the Chancery Court of Fayette County over 2 years after the petitioner and Mr. Minor. Mr. Minor was Miss Tapp's longtime attorney. He had done various things for her over the years and had a very good and strong attorney-client relationship, and that the trial court appreciated that fact that Mr. Minor was her attorney, but also acting as her co-conservator. John was a relative of Miss Tapp, and he's the one that kind of got the ball rolling. But John and Mr. Minor were appointed as co-conservators. 2 years after that, the siblings filed a petition to remove John as co-conservator. In their petition, they said John was not performing his duties and he was not acting in the best interest of Miss Tapp. The siblings asked the trial court to remove John and appoint a different sibling, Miss Bishop, as his successor. On July 31st and September 11th of 2018, the trial court heard the petition to remove John, and 6 of the siblings testified on why John should not be Miss Tapp's co-conservator. Trial court also heard from the ward's caregivers, Dr. Pettigrew, Mr. Minor, the co-conservator, Ruth Ann Shelton, who was the executive director of the Alzheimer's and Dementia Services of Memphis, also testified. And at the conclusion of the hearing in September of 18, the trial court rendered an oral ruling, and the trial court explained that it was dismissing the petition to remove John as co-conservator. And the court also awarded attorney's fees to John and Mr. Minor as the prevailing parties. As the prevailing parties, the trial court awarded John and Mr. Minor $33,424.34 in attorney's fees under 34.3107 and 34.3108. So the dispositive issue on appeal was, did the trial court have the authority to award attorney's fees to counsel for the co-conservators? The court got into the discussion about subject matter jurisdiction. There was some question whether Ms. Tapp resided in Haywood County or Fayette County. The court determined that that issue really had been waived, but the court went on to address the subject matter jurisdiction issue, but said that was not a problem, that Fayette County absolutely had authority and it was proper to be filed there. They raised a due process issue as well, but the court said that that did not apply. After denying the siblings' petition to remove John as co-conservator, the court concluded that it was in the best interest of the ward to maintain a relationship with the siblings. So the siblings had a visitation schedule with Ms. Tapp. I don't know exactly what that was, but that's really not pertinent to what we're talking about. But what it really came down to was, if the court kind of said if the siblings were attempting to enforce rights, attempting to enforce that visitation schedule, then and they didn't prevail, the co-conservators prevailed, then that might have been sufficient for, as a prevailing party, to award attorney's fees. But here, all the siblings were doing was trying to remove John as the co-conservator. The trial court did not disturb what already existed regarding their visitation schedule with Ms. Tapp. And so the Court of Appeals said
John and Mr. Minor were not prevailing parties because there wasn't any attempt to enforce or modify any kind of rights pursuant to 108. So the prevailing party in a petition under this section, section F, shall be entitled to court cost and reasonable attorney's fees. That's the statute. That's 108F. The rights for which a party may petition the court pursuant to this statute include the right to communicate, visit, or interact with the ward. Persons granted the authority to file such a petition include the closest relative or relatives of the ward. So certainly the siblings had a right to file that, but the point was they weren't trying to enforce or obtain rights to communicate, visit, or interact with the ward. They already had that, and the trial court didn't disturb it. So the Court of Appeals said it's clear that siblings did not file a petition to seek visitation or communication rights with the ward pursuant to 108F. Their filing went beyond that. Their petition alleged concerns that John was failing to perform his duty as a conservator to act in the best interest of the ward. Further, many of the allegations of misconduct against John did not relate to visiting or communicating with the ward, and included claims that John did not provide appropriate care for the ward and failed to keep the ward's home in a suitable condition. The petition contained requests for several forms of relief, chief among them John's removal as conservator. Their petition did not, and this is where they really hung their hat, did not include a request for the court to grant them visitation or any other rights listed in 34.3.107A2P. So although the trial court correctly found that the petition was filed under 34.3.108A, it went on to award attorney's fees as if the petition had actually been one filed under 34.3.108F, seeking the right to communication, visitation, or interaction with the ward. In doing so, the trial court applied an incorrect legal standard, and the Court of Appeals found this was the siblings' petition to remove was not filed under 34.3.108F, and frankly, they're quite lucky that it wasn't. Because had they also sought that relief, I believe the Court of Appeals would not have disturbed the trial court's award of attorney's fees. So it's an interesting read. Again, not a very long case. I think it's about 12 pages long. And this one is published. Well, let's see, this one came from, this was actually published from Lexis. So it actually just has a Lexis number. It doesn't have a Southwest number. But that's worth a read. And again, that's probably the most recent conservatorship case that I could find on appeal. And it's definitely worth pulling out, but the Inrated Conservatorship of TAP. So now I want to talk about a little bit, I mentioned in opening, orders of protection for adults who have been subjected to abuse, neglect, or exploitation. This is something I think relatively new to most folks. I'm sure those of you who do exclusively conservatorship work are probably familiar with it, but it is a tool in which I think we need to consider using more often. We have a case now, and it's a very, very sad case, but we have a gentleman who is disabled. However, he was working a full-time job here at one of our factories in Lebanon and doing really well. And this woman found him. I don't know exactly how they connected, but she came in and swooped in and took over. And she has now, they have disappeared. I would say almost absconded. And there's a couple of attorneys involved, and they've done everything they possibly can to try and track them down, and hiring private investigators and so forth, and had a lead on them, in Rutherford County possibly, but still haven't actually made contact. But the point is, this woman, according to the petition and the evidence that has been presented to the court, is taking advantage of this individual, such as financial exploitation. And this would be a situation, and it is a situation where the attorneys have brought an ex parte order protection application to the court because of the financial exploitation, and the court has issued it, but she's not been served because they can't find her or him. So it's a difficult situation. And we're hoping for some good luck to be able to track them down and get in and figure out exactly what's going on. But orders protection using, a lot of folks wouldn't think, well, could we use this to protect a ward or respond in a conservatorship? And absolutely yes. So any relative conservator, anybody from Tennessee Commission on Aging and Disability, a designated assign of the Relative Conservator Commission, or an attorney ad litem having personal knowledge. Now that's the key, having personal knowledge that such an adult is threatened or with or placed in fear of violation of any of the offenses enumerated. And those are the criminal code sections regarding the financial exploitation or elder abuse there, Title 3915, and that's the family offenses against the family statutes. Any of those persons may seek relief for the adult pursuant to this section by filing a sworn petition with any court having jurisdiction, alleging that the respondent has violated or threatens to violate any of those enumerated criminal code sections, regardless of the existence of any remedy at law. So it doesn't matter whether there's a criminal case proceeding, you can still come and seek the civil remedy of an order of protection. And we can do some things and prevent contact. The petition, if filed, must allege facts based upon personal knowledge of the petitioner. And I mentioned that's key, that the adult either lacks the capacity to consent or that appearing in court to the petition on the adult's own behalf would pose an undue burden on the adult. So it's a good tool. I'm going to go over some definitions. So abuse or neglect means the infliction of physical pain, injury, or mental anguish, or the deprivation of services by a caretaker that are necessary to maintain the health and welfare of an adult, or a situation in which an adult is unable to provide or obtain the services that are necessary to maintain the person's health or welfare. Section B, I thought is very interesting, means adult or abuse or neglect also means transporting an adult and knowingly abandoning or leaving or failing to provide additional planned transportation for the adult if the adult's caretaker knows or should know that the person is unable to protect or care for himself or herself without assistance or supervision, and the caretaker's conduct causes any of the results listed in subdivision 1A or creates a substantial risk of such results. So if somebody takes a vulnerable adult somewhere and just drops them off and doesn't provide further care, they're subject to this statute, 716102. Exploitation, this is one of the definitions here in the welfare statutes. I bring this up because I'm going to contrast it to the definition in the criminal code. So in order for someone to have committed exploitation under the welfare code, it means the improper use by a caretaker of funds that have been paid by a governmental agency. So in other words, Social Security benefits. However, if you look at the criminal code, financial exploitation, and I apologize, I thought that I had that in a larger font, but hopefully y'all have screens that you can see it. But under the criminal code, 3915-501, financial exploitation does not have the limitation of funds paid by a governmental agency. So here it's the use of deception, intimidation, undue influence, force, or threat of force to obtain or exert unauthorized control over an elderly or vulnerable adult's property with the intent to deprive the elderly or vulnerable adult of the property. It also is the breach of fiduciary duty to an elderly or vulnerable adult by the person's guardian, conservator, or agent under a power of attorney, which results in an appropriation, sale, or transfer of the elderly or vulnerable adult's property, or the act of obtaining or exercising control over an elderly or vulnerable adult's property without receiving the elderly or vulnerable adult's effective consent. Well, here, I mean, we've got a person, if we have a person under conservatorship, they can't consent to it, so that wouldn't apply. But I did find it interesting that we had this contrast that for exploitation under the definition with the welfare statutes, it has to be money that is paid by a governmental agency. When you go to the criminal code, there is not that limitation. So they're trying to, if the individual, the perpetrator is exercising or exerting control over any funds, doesn't matter what the source of the funds is. The offense of financial exploitation of an elderly or vulnerable person it is an offense. It's punishable pursuant to theft, which is under 39-14-105 at SEC. And if a person is charged with financial exploitation, the conservator or other interested party has the ability. The prosecuting attorney can do this. They can actually seek a remedy in civil court, and I think maybe another statute. But they also, if the amount taken or is more than $5,000, they can go to civil court and actually seize assets of the perpetrator. Which I think is a great remedy. We're not talking about waiting for restitution in the criminal prosecution. The prosecutor can be proactive and go and seize assets of this person and say, we think that this person has stolen or misappropriated from this vulnerable adult. Would you, civil court, Chancery Circuit Court, would you please put a hold on this person's house or their bank account or whatever asset that you can find out there, so that we can make whole this vulnerable adult who's been taken advantage of? I think this is a great statute. A conviction under this section ranges from a misdemeanor, which is kind of an attempt deal, up to an E felony and also a D felony. So there can be some severe, I believe, what a D felony is 2 to 4 in range 1, I believe, if my old criminal prosecution days, I remember. As I conclude, want to give time if there are any questions, but want to bring everybody's attention to 34-3-1044, and I want to give credit where credit is due. Judge Kennedy, I mentioned that we had presented last week in a probate forum and with the National Bar Association, and Judge Kennedy sent to the judges, and may have sent it to all participants, but it is tips for adjudication in conservatorship and guardianship cases. And it's really kind of a checklist for judges: is if this, then this, do this, make sure that this is done. It is absolutely fantastic. And I wanted to thank him for it. I didn't get a chance to do so last week, but it is a wonderful summary of the conservatorship process from start to finish. And I'm very appreciative of that. But in that information, he included, as of January 1 next year, conservatorship petitions, in addition to all of the information that's required to be in there, and you all know what that is, it must include current copies of the following reports of the proposed conservator, or on the proposed conservator. So you're going to have to include a copy of the search of the Department of Health's Registry of Persons who have abused, neglected, or misappropriated the property of a vulnerable person, and that's Title 68-11-10. And also a search of the National Sex Offender Registry maintained by the United States Department of Justice. And current, I'm not sure is defined. That's one thing might have to look at, but I would take current no more than, say, 30 days old, I think would be a safe bet. But I do believe that anything older than that would probably be considered stale by the court. So with that, I would open up to any questions. I want to thank everyone. I hope everyone has enjoyed this hour-long nap that we've had, but I've greatly enjoyed speaking with you, and certainly look forward to serving on the board with such great folks. And you all do great work, and oftentimes for you conservators out there, it's kind of a thankless job. But I want to thank you personally for what you do, because you're assisting someone with, particularly most often later in life, who can't help themselves. And your willingness to do that speaks very highly of you and your integrity. And so I thank you all for doing that.